Welcome to Infringe at Your Own Risk.
Hello and welcome back to Infringe at Your Own Risk with Rand Bateman. Rand is a registered patent attorney with decades of experience protecting patents, trademarks, and copyright for clients from startups to international companies. My name is Kevin Rosenquist, and today Rand is going to walk us through the steps needed to file a patent. Rand, welcome back.
Thank you. Good to be back.
All right, so pretty simple. So tell us, we're a patent podcast. What exactly are the steps involved?
Okay, so let's walk through from the beginning. Now, I'm going to be talking about utility patents. In a prior episode, we talked about the different types. There's utility patents, which is what most people think of as patents. There's design patents, and there's plant patents. So to give you an idea of where things fall, last year, the Patent and Trademark Office issued a little over 300,000 patents, utility patents. They issued about 34,000 design patents, and they issued a little over 1,100 plant patents. So plant patents are pretty rare. I've never actually done one in my career. There's probably very few attorneys who have, just because they're so rare relatively. But we're going to talk about the process if you have in a utility patent. The utility patent covers something with a utilitarian purpose. It's a system or a composition of matter or a process that improves upon what we have. So the first step is you have your great idea. In patent law, you will hear patent attorneys say you can't patent an idea. And what they mean by that is if you say, my idea is to fix problem X, okay, that's an idea, that's not patentable. In order to have something patentable, you have to have a solution to the problem, and you have how you're going to do it. And how you do it is what's patentable, not the idea of doing it. So if you ever hear a patent attorney say you can't patent an idea, that's what they mean. Okay. So the first step is you've got your invention. It's to find out, has anybody done this before? Because believe it or not, a lot of really good ideas happen. People got patents on it, but they just never figured out how to get it to market. So it can be, sometimes it was done a long time ago. One of the first projects I ever worked on as an attorney was a little device that would help keep your lines from freezing in the wintertime, your water lines. And lo and behold, when we tried to proceed with the patent on it, somebody had built almost the exact same thing back in the 1850s. Oh, okay. I mean, it was 100 years old, and it's like, wow, okay. And so, but it wasn't out on the market, and my client was making a lot of money with this little device, but it had been invented by somebody else, but they just never got around to getting it in the market, or it was in the market 150 years ago and then stopped for some reason.
And failed or something.
Or whatever happened. But it was, and it was actually used for a slightly different purpose, but structurally it was the same thing. And so that probably had something to do with it. So the first step is doing a patentability search. You can do your own if you want. You can go to the Patent and Trademark Office has relationships with various libraries that you can go in, and there's facilities there that they can help you search. Google has made this much easier because you can hop on patents.google.com and you can get in and look. And the key is you're trying to find the closest thing you can to what you're doing. And the key on the patentability is your change or your improvement. Has that been done before, or have other people done something similar enough it would be obvious to do? I would strongly recommend that you get a professional patent search done. And the reason is that the people who do searches, they know the Patent and Trademark Office classification system. So when you show up with an invention at the Patent and Trademark Office, they have this big long flow chart that they move your invention through to decide where it fits. It's a skateboard that has wheels that glow, all these classes and subclasses. And that's where they're going to look to see if it's patentable. And so if you have a professional patent search done, the searcher will go through and do that analysis to find the closest art. You can do word searches, but word searches are tough because people will use different words to say the same thing.
Mm-hmm.
Is it a ledge? Is it a flange? Is it an arm? It can be called several different things. Well, if you search for an arm and they called it a flange, you're going to miss it.
Yeah, it's not going to come up.
And I don't do my own searches. I have a company that I've worked with for at least 15 years that I run all mine through just because they're more efficient at it. That's what they do. And so I will send it to them, and then they will send back to me, anywhere from the 5 to 10 patents that they found that were closest to the invention that I'm looking at. And then I'll go through and say, okay, here's what this one shows. Here's what this one shows. Here's what this one shows. And I look to see what are the things about mine that are different than what these show. And then we isolate that. And that's the inventive concept. And then I sit down with the client and say, okay, here's the inventive concept. You've got this that doesn't appear to be shown in the prior art. Then the next part of the analysis is, okay, is that inventive concept worth anything? Because you can have something that's inventive, but the question is anybody going to pay money for it?
Mm-hmm.
Right? If it's just different, just because it's different doesn't mean it's better. Right. And so is anyone going to pay you anything for it? And it's like, yeah, people want something that will do that. Okay. Then it's worth pursuing a patent on. If it's not, it's just different, then you can still pursue a patent on it, but it's really a vanity patent. Right? I got my name on a patent. It goes on the wall. No one's ever going to pay me a licensing fee. I'm not going to pay them money to go out and make the product. So I have a vanity patent.
Mm-hmm.
But if not, you say, hey, you know what, that is better. And most inventions qualify for that because they're created in an effort to solve a problem. Why is there this? If you watch late night TV, you'll see things that you can use to grip the top of a jar of something and turn the lid off. Okay, well, who came up with that? Somebody who had a hard time getting a lid off.
Right.
And my wife will frequently just hand me something and say, "Here, do that." And
yeah,
I'll take the lid off.
Mine too. And sometimes I go and I get that little rubber thing to get the lid off.
Exactly, because sometimes you can't do it either. And if you're older, if you have problems with your hands, it can be really difficult to get those off. So somebody said, "Hey, you know what? If I do this, I can make something that makes it easier for people." And that's kind of the best thing is if you're inventing something that makes people's lives better.
Mm-hmm.
Right. I mean, that's the way, A, it's a way to make money, and B, it's a way to feel good about making your money because you're making your money improving people's lives.
Sure.
And that's cool. And that's one of the things I really enjoy about being a patent attorney is when I get to work on those. Years ago, I may have talked about this on a prior episode, but years ago, I was getting some photographs of my kids. And we were sitting there and there was another lady there and she, took off the little girl's shirt and she was changing it. And then the girl had a stoma tube, which is a tube that goes into your intestines. Looks like a little button. You open it and stick it in. Well, that's how this little girl feeds. Okay. She can't eat normally. So they pump a solution into her intestines and that's how she eats. And I looked at it and apparently too long. I'm kind of bad on social cues like that. And the woman said, "Are you a doctor?" And I said, "Well, no, I'm not." And she said, "Well, I just saw you looking at my daughter's digestive tube." And I said, I really apologize. I didn't mean to. I have a client that's in that field. And I have natural curiosity about it because I've done multiple patents on it. And she goes, "Well, what's your client's name?" And I told her the client's name and her eyes start watering. And I'm going, uh-oh, what did I do? I mean, and her eyes, and she looked over and she said, "Would you tell your client that I love them?"
Oh,
and I'm going, goodness. Okay. And my kids are all like, "Dad, what did you do?"
Yeah, right.
And
Seriously.
and she told me that, and I said, well, yeah, sure, I'll tell them, because I was good friends with the CEO of the company and a lot of the people there. And I said, well, why? And she said, well, I have two daughters that both are adopted and both have this medical condition. And she said, my oldest daughter went through high school. Every 2 hours, she had to be hooked to a pole and have her food put in a bag, and it fed down into her intestine through this little tube. And my client had invented a little pump that's about the size, about twice as thick as a cell phone, and about the same footprint as a cell phone. And it would pump the solution in. So a girl could wear a fanny pack with her food in it, the pump, and a little tube would just go under her shirt. You wouldn't even notice it. It goes into her tube. She could be in class doing everything. She could
Yeah.
skateboard, or the first, when they did the final test of the product before they released it, they took a little boy camping. He'd never been camping before, but he could go camping because of this little pack he could put on. It would feed, and even better than hanging from the pole every 2 hours, it fed him continuously, and it would track how much he'd eaten, and it could do all sorts of really cool things. And she just said, I tell them I love them. She said, because this daughter can do all the stuff her older sister couldn't do because of your client's invention. And then I turned to my kid and said, yeah, that's what I do. That's what I do for work.
Yeah.
Because as an
Wow, that's a
attorney, you
crazy
don't get to
story.
show your children the house you built or
Yeah.
the car you built or anything like that. And but we had to look, okay, what was the inventive concept? And there were several different inventive concepts that they pulled together in this little pump. And we went through, and I think we ended up with like 25 different patents on this. But it made people's lives better.
Mm-hmm.
And that's what the patent process is kind of about, in the attempt to develop new products. We're making things better. So we do our search. Here's the points of novelty. Then we write up a patent application. Now, the patent application can be done one of two ways. The fast and easy way is doing a provisional application. And there the goal is just to get disclosure. Here's what my invention is. You want as much information about the invention itself. And you file that, and then you get a filing date that says, I got here on this date. And the reason that's important, up until 2013, the US was a first to invent country, one of the very few in the world, but which meant if I invented it first, I won, even if someone else filed for their patent application before me. And that really helped small inventors, because they don't have the big budget to spend on a lot of R&D. And some people took 10 years trying to perfect their invention before they filed their patent application. In 2013, that's changed. So now it's the first inventor to file. So it's very important to file promptly on your invention. If you wait too long, you can lose your rights. So that's a provisional. A provisional lasts for 1 year, and then you have to file your non-provisional application. You can also file your non-provisional application right away. You don't have to file a provisional. The non-provisional application is what gets examined by the Patent and Trademark Office. And if you look at a patent, you will see there's nice drawings. There's a description, what we call the specification, that talks a little bit about here's the problem I'm solving. And then it gives a detailed discussion of how I'm solving that problem. Okay, that's the information that needed to be in the provisional application. Then at the end of the patent, there is what we call the claims. And it'll say, I claim, and then it'll have words that describe the invention. And the goal is to use as few words as possible to describe what the invention is. And if somebody makes a product that follows all of those words, then they infringe. So in a non-provisional application, the claims are by far the most important part.
Mm-hmm.
Right? As long as you've just reasonably disclosed your invention, then it's how you do those claims. And so on a non-provisional, a lot of work goes into, okay, how do I describe the inventive concept here to cover things without adding unnecessary language? Because the more language that's there, the more likelihood that a potential infringer doesn't have at least one thing that's listed in your claims.
Right.
right? If I claim it has to have 4 wheels and they only have 3, they probably don't infringe. In most situations, they wouldn't infringe. So that's the next step. So the patent, you're going to sit down with your patent attorney and you're going to write up this application. He's going to write it or she's going to write it based on the information that you provide, which is why it's important to provide complete and accurate information. Sometimes the patent attorney is writing based on what they think you're doing and not what you're actually doing. So it's important that you provide. I had a client once, we sent them their patent. Their patent got issued, and I got a call from the engineer, the lead inventor, and he said, "This is really cool." I said, "Oh yeah, it's really cool that you got a patent." He goes, No, the way you did it." I said, "What do you mean?" I had written up this patent. They told me, we're solving this problem. And based on the limited information I have, I wrote up what I thought they were doing. And it wasn't what they were doing.
But it was better.
And yeah. And he's like, "We really like what you did here." And I'm like, "Well, do you remember that thing called a declaration that you signed when we filed the patent where you said, I reviewed this and it states my invention," right? You have to sign a declaration that this is your invention when you file it. And unfortunately, sometimes people don't actually read what you send them.
Yes, that's true.
It's like, "Oh yeah, that's fine. Just go ahead and file it." It's like, well, did I get it right? There's one attorney who got tired of clients not doing that. And he actually wrote in, this is the part that I put in here to see if the client actually read it, because they usually don't. The dumb thing is he forgot to take that out when he filed the patent application. Okay. And I would hate to be his malpractice carrier. So, so you write up the invention with your patent attorney, make sure it fully discloses your invention. The patent attorney is going to do the claims. Clients sometimes get upset with me because they read my claims and they're like, "Well, it doesn't talk about this and it doesn't talk about that." It's like, well, no, those are independent claims. You don't want to put everything in claim 1 because then you have a very narrow claim. So we go through that process. And then when it's ready, we file the application with the Patent and Trademark Office. Patent and Trademark Office says, yes, we received it. And then they sit on it. And it depends on what art unit you're in. And they can sit on it from anywhere from a year to 3 years. I've got a couple that are actually over 3 years right now. And then they take it up and they give what's called an office action. So they go through it and they say, okay, what in here, are there any problems? And sometimes the examiner will say, oh, there's a problem. Item 33 that's discussed in your specification is not on the drawings. And okay, we can fix that. Or, this isn't clear what's happening here. And so you address that with the examiner. Often they look at the claims and they'll give typically one of 3 different rejections. Number 1 is they reject it because the claim isn't clear as to what you're claiming. Sometimes I called the first item has this and the second item has that. And then later on you talk about that as being on the first item. And the examiner says, well, this doesn't make sense because that should be on the second item. You say, oh, you're right. I made a minor error here. Let me change the word first to second. And that's called a section 112 rejection. And those are fairly commonplace. Mm-hmm. Then the other 2 that you deal with are the art-based rejections. And number 1 on that is it anticipated? So they'll look at your claims and say, okay, can I find another patent publication or something else that teaches everything in that claim? So I walk through all of the verbiage of the claim, and if something else teaches it, it's shown in another patent, whatever, that claim is rejected as being anticipated. Okay, so I have to change that claim to describe my invention without describing the prior art that the examiner is looking at. Mm-hmm. The other type is an obviousness rejection. The examiner says, well, this reference I have isn't exactly like your claim, but in light of this other reference that I have, it would be obvious to change it to have what your claim has. And so, sometimes the examiner's right. You look at it and say, yes, if I knew about both those patents 20 years ago, I would have said, sure, you can swap out part A for part B.
Right.
And sometimes they're not. Sometimes it's like, wait a minute, you're combining, a bullet target with a muffler. Okay, why would anybody who's skilled in the art of making bullet targets look to a muffler on a car and say, oh, this solves my problems? And so you go through that. So about 95% of patent applications get rejected the first time, first office action. So it is by no means a death nail. I mean, vast majority of patents that have ever issued get rejected on the first time. In fact, sometimes as attorneys, we get a little concerned if it gets allowed the first time. Did we claim way too narrowly? Is there something we put in there we shouldn't have put in there? And we look for that. So it goes through, it gets a first office action. So you get the office action, and then you respond. And sometimes the office action will say part of it's allowable, part of it's not. The attorney then either rewrites the claims, addresses the issues, and then responds to the patent examiner. And hopefully the patent examiner says, okay, yes, now it's patentable. You pay a fee, and then you have a patent. Sometimes the examiner has found good enough art that you say, yeah, we're not going to get a patent here because they found something.
Okay.
So that's the process. Typically it takes anywhere from 2 to 4 years from the time you first file to the time you have a patent issued.
Wow. It's a long time.
It is. And, the cost can be anywhere from $10,000 to $50,000, depending on how complex the patent is and the prior art. But it's important if you're an inventor to sit down with your patent attorney and just walk through what things are likely to be for mine. I mean, obviously a very simple patent tends to go faster and it tends to cost much less. I saw a patent the other day that was about 250 pages long in text writing. Obviously that's going to be a much more expensive patent.
That's
one
crazy.
that's 15 pages long.
Pages.
Yeah. And so it's, but that's the process. So if you're a patentee, if you've got an office action from the Patent and Trademark Office, don't get discouraged. Sit down, talk with your patent attorney and say, okay, is this something we can overcome? Because it usually is. And I've had clients who have gotten really stressed because we had a very minor thing that we had to address with the examiner. I want this change, this verbiage changed to that. And the client's like, what? My patent application got rejected? And you go, yeah, it's going to take me 15 minutes to fix. Right. And it's no big deal. So, don't freak out if you're a patent applicant. Don't freak out. Talk with your attorney. This is one of the reasons I say the best attorney you can get is one that you can communicate well with.
Yeah. Because
if you have a good relationship and can talk to them, you can avoid a lot of issues and end up with a much better patent on the back end. So.
Well, awesome stuff, man. Thank you for going through all that with us. Thank you for joining us on Infringe at Your Own Risk. Certainly hope that for anyone out there who's considering a patent, or like Rand said, maybe you got a first office action, don't freak out. Just contact Rand and his team, batemanip.com. He can help walk you through it just as he did today and get you on the right track. Don't forget to subscribe to our channel. Leave us a review. We love having you here. Rand, awesome stuff. Thanks so much for all the insight.
Thanks, Kevin. Good to be here.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.